Hello, I'm Joanne Bone and I'm a partner at Irwin. I've been a data protection lawyer for over 20 years, and today we're going to have a look at the new legislation which regulates data protection, GDPR. We're going to have a look at it in the context of education. It's definitely a hot topic, but it's also a topic that is the subject of a lot of misinformation. So one of the things we're going to do today is look at some of the GDPR myths that are doing the rounds and do some myth busting. So in terms of what we're going to do, we're going to have a look at what GDPR is, what does it apply to, why do you need to be bothered, and what do you need to do to prepare for it. Our view in relation to GDPR is that slow and steady wins the race. Essentially, you need to have a methodical way of preparing for GDPR. It doesn't involve things that are very difficult, but it does involve considering its application throughout the whole of the organisation because it's root and branch reform. This is why a lot of our imagery is centred around running, because we very much think it is a marathon and not a sprint. Although, as you will see in a minute, since it will need to be fully in force and you will need to be compliant with it by 25th May 2018, it is becoming more of a sprint now than it was when we first started to talk about it. So having a look at what the scope of GDPR is and how it's structured, GDPR is European legislation. It's been through the EU legislative process, and it won't be gold-plated from the point of view of UK legislation, in terms of we are not going to take it and put it into the normal sort of language that would be used in UK legislation in terms of acts. It's written in fairly broad terms. So what that means is that guidance is key, and there is quite a lot of guidance that is being issued at the moment. The Information Commissioner, which is the UK regulator, is issuing guidance, and also the Article 29 Working Party is a pan-European guidance body, and they're also issuing guidance in relation to it. So I'd strongly advise, in terms of the way in which it's written, as I say, it's in broad terms, that you also consider guidance in conjunction with GDPR. As you will see from the slide, and as I've already mentioned, it will come into force on 25th of May this year. There will be no grace period. The grace period is now. It will have full force and effect from that date, and you should be compliant by that date in May this year.
But what about Brexit then? So if GDPR is a piece of EU legislation, then isn't it right to say that it won't be relevant in the UK after Brexit?
It's an interesting point, Claire, that you raised, and I think there's a lot of people that have taken that view and put their compliance projects on hold. In fact, Brexit won't affect GDPR, not least because the government is pushing through a data protection bill at the moment, which will become the Data Protection Act 2018. And what that will say is that GDPR will take effect in the UK. Now, I've already said it won't be gold-plated. It will add some information in relation to exemptions and things, but it won't change the main text of GDPR, which will be incorporated by referring to it. So no, anyone that's put their compliance on hold as a result of Brexit needs to restart it very quickly, because we will be bound by GDPR regardless of Brexit. The first thing we're going to do before we have a look at what the requirements of GDPR are is have a look at what's covered by it in terms of what's its scope. GDPR applies to the collection and use of personal data, which begs the question, what's personal data? Personal data is information relating to an individual, and it identifies them either directly or indirectly. So, for example, name, address, date of birth, email address, they're direct identifiers and will be regarded as personal data. IP addresses are also expressly referenced as personal data under GDPR. Also, if you're referring to a very small group of people, which therefore essentially allows you to identify them, that too is an indirect identifier in relation to the individuals. So it's potentially pretty broad. GDPR applies to the processing of personal data. Processing is a very broad church in terms of it's a cradle-to-grave definition. Any use of personal data will be regarded as being processing. It applies to automated processing and also non-automated processing. So automated processing is processing via computer, and non-automated processing is the keeping of structured paper records.
So John, it might be likely that within a school, for example, certain teachers keep their own lists of names or their own paper files and that kind of thing in their classrooms, for example. Is that likely to be covered by GDPR?
It may well be, Claire, and I think this is something that a school needs to understand in terms of what databases are being kept by people in unofficial databases, because it may well be that these are not something that should be kept. These may well be something that the school should be regulating. So I would, as part of the data audit that we'll talk about in a minute, have a database amnesty, so people come forward and tell you what databases they have, so you can have a look to see whether or not it's something that they should be keeping, or whether it's something that you feel that it's not really appropriate. Ultimately, the school will be responsible for what databases are within the school, so it does need to understand what these unofficial databases are. The other thing that we need to understand are the two types of personal data. There's ordinary personal data and there's special categories of personal data. I'm going to have a look at what comprises special categories of personal data, simply because ordinary personal data is everything else, so it's easy to sort of work out sort of what's not in the definition of ordinary personal data, rather than just trying to find what it is. Special categories of personal data are controlled more strictly under GDPR, and they relate to things like racial and ethnic origin, political opinions, religious or philosophical beliefs, trade union membership, genetic data, health data, biometric data, data relating to an individual's sex life or sexual orientation. This is all special categories of data. It used to be called sensitive personal data, and the use of it is more strictly controlled and restricted. One of the questions that I quite often get asked in this context is, well, what about financial data? Obviously, schools will be potentially holding financial data, maybe in relation to employees in terms of bank account details and things. Financial data is technically ordinary personal data, but it should be given an extra layer of protection, since any data breach which affects financial data will be regarded as more serious. So it's probably a good idea to think about there being three categories of data. So you have ordinary personal data, which gets protection under GDPR, but not as much protection as the others. Then you have financial data, which is a sort of special category of ordinary personal data, and then you have proper special categories of personal data that get the top level of protection. I think one thing that does need to be borne in mind in the context of a school is how broad that the impact of the definition of personal data might be. It will obviously apply to pupil data, it will apply to staff data. You also need to think about it in the context of suppliers. Now, personal data doesn't apply to company data, but it does apply in the business context. So, for example, sole traders and partnerships, they will be regarded as individuals. So if you have suppliers and supply arrangements with people who are sole traders or partnerships, then that will be regarded as personal data. And equally, if you're capturing personal data of individuals within a corporate environment, so within a company, then their data, the individual data, will still be personal data. So if you think about it, it will impact on lots of different areas in which a school operates. Now we've thought about what the legislation is going to look like and what it's caught by, we're going to have a look at how best to prepare for May this year. The first thing that I think you need to do is to carry out a data audit. You need to understand what data you've got, how you are using it, who you're sharing it with. If you don't know what you've got, then you can't make it compliant. One of the other things to bear in mind in the context of this data audit is that if you have more than 250 employees, you also need to think about a mandatory data record that you need to keep. You are required to document a lot of the information that will come out of the data audit under GDPR if you have a larger number of employees, so more than 250. There is some information which is set out in Article 30 of GDPR which requires you to certain fields that you have to keep. We would also suggest that in order to keep records together and make it easy for yourself from a compliance point of view, you should add on non-mandatory information as well. And certainly that's the approach that has been taken by the Information Commissioner. The Information Commissioner, the ICO, has issued some recent guidance in relation to what they think, some helpful guidance in terms of what Article 30 records might look like. It's not mandatory, you don't have to do what they say in terms of setting it out, but they are suggesting some fields that you might want to include. The other thing that's not mandatory is they've suggested that you do it on an Excel spreadsheet, which is absolutely fine, but you could also do it on some software. The method of keeping that record isn't prescribed by law, but it is something that if you have more than 250 employees, you need to think about.
So who do you think should be taking responsibility within a school for carrying out a data audit and for GDPR compliance?
I think there is a temptation, we're finding, for people to decide it's an IT problem or it's an HR problem and just give it to that team within an organisation. Hopefully, as I've just explained in terms of the sorts of personal data that are caught by GDPR, it applies across the whole of the organisation. It's root and branch reform across all aspects of an organisation. So essentially what you need to do is put a project team together which pulls on expertise and people who understand how the data is used in the various different teams within the business. You obviously need a project leader, and it may well be that you pick that project leader from an HR team or from the IT team, but everybody essentially needs to take responsibility for GDPR compliance. One of the other things that you do need to bear in mind is that you need to document your compliance. There is an obligation from an accountability point of view to make sure that not only do you do the right thing, but you document the fact that you have done the right thing. And so one of the things we'll be talking about are the sorts of records that you should be keeping. Also, before we move on, we're going to have a look at next the lawful purpose, which applies to whether or not you can legally use the data that you have collected. As part of your data audit, and as you need to do an analysis of how you're using that data and whether or not you have a lawful purpose which allows you to use it legally, one of the things you should not do is fall into the trap of assuming that because you could do it under the current legislation, the 1998 Data Protection Act, you can definitely do it under GDPR. As we'll sort of talk about, the lawful purposes under GDPR are slightly different to those under the Data Protection Act, so it is something that you need to come at with fresh eyes. Looking at lawful purpose, essentially lawful purpose is, it's probably easiest to think of it as a gateway in terms of, can you establish that your collection and use of the personal data falls within one of the gateways that's on the slide. There are different gateways for ordinary personal data and different additional gateways for special categories of personal data. As you'll see on the slide, there are a number of different gateways that you might want to consider for use of the ordinary personal data. The first gateway we'll have a look at is legitimate interests. Legitimate interests is a gateway that requires a balancing act to be undertaken. Essentially, you show that it's for the legitimate interest of the organisation and you're not riding roughshod over the privacy rights of individuals. The difficulty of legitimate interests in the educational context is that it's not available to public authorities, and the scope of what comprises a public authority isn't yet clear. So if you're an independent school, then it's something that will be available to you potentially. If you are a local authority maintained school or an academy trust, it is something that needs some quite careful thought as to whether or not you will be excluded from using it. The alternative, if legitimate interest is not available to you, is to demonstrate that what you are doing is necessary for the performance of a task carried out in the public interest, and you'll see that that's there on the slide. The next bullet point relates to consent. There are a lot of misconceptions surrounding data protection, that consent is absolutely the best lawful purpose to legitimise your use of personal data. I am not keen on consent for a number of reasons. The first is that consent under GDPR is going to be difficult to obtain. You'll have to be clear with people what it is they're consenting to, and there will have to be some sort of active acceptance of what it is that you're requesting them to do. So pre-tick boxes are dead in the water in the context of consent. The other thing that I don't like about consent is that it can always be withdrawn, and so if consent is withdrawn, then you can't process the personal data anymore. And it's also not available where you've got an imbalance in the relationship. The employer-employee relationship is one that's in sharp focus in relation to this, and certainly the view of the ICO, the UK regulator, is that an employer-employee relationship is imbalanced. You can't, therefore, if the consent guidance remains, use consent to legitimise your use of personal data in the employment context with your employees. So what that would mean is you potentially need to look at new starter packs and also at employment contracts and think about whether or not there is an alternative lawful purpose that you can use. One of the ones that's worth considering in the context of both employees and elsewhere is whether or not the personal data is necessary for performance of a contract. So in the employment context, obviously you will collect information in terms of bank account details, and one of the reasons for that is in order to make payment. That's performance of the contract with the individual, so that sort of thing is permitted there. Also, surrounding payroll information, there will be certain payroll information that will need to be provided to HMRC, which falls into the next bullet point, i.e. compliance with the legal obligation. So you just need to think through in terms of what you're doing as to whether or not, particularly in the employment context, you can legitimise what you're doing as necessary for performance of the contract or necessary for compliance with the legal obligation. You'll see that there's also a reference to protecting the vital interests of the data subject or someone else. Essentially, that's primarily life or death situations, or certainly very serious situations, so it's not widely used. I'm quite often asked whether or not there's a hierarchy in terms of should you go for one lawful purpose over another. I don't think that you should definitely work through them in a particular hierarchy, but the one thing I would say is you potentially need to put consent to the end. You need to make sure, well, I would suggest that you have a look to see whether or not any of the other ones apply before you start relying on consent, simply for the reasons that I've already highlighted. One area, however, that consent is very relevant is in relation to marketing. Certainly the ICO very much likes consent in the context of marketing, because they like individuals to understand what it is they're consenting to. And whilst you may not think that marketing is that relevant in the context of education, it does raise its head, and it is relevant in terms of if you are promoting maybe, I don't know, where to get a school uniform from or something like that. And so it can't be discounted. To the next slide, we're having a look at what we should think about in the context of dealing with children's data. Children are regarded as vulnerable individuals, and you see that on the slide, and therefore they get particular protection under GDPR and data protection. Unfortunately, it's not entirely clear as to what age someone is a child and when they cease to be a child. Under GDPR, it can be set anywhere between the ages of 13 and 16. And in the education context, obviously there's a big difference between year 8 when they may be 13 and sort of when they're 16 in terms of the level of understanding and how you would engage with an individual. There is some guidance in relation to children and the age they cease to be a child, where you're dealing with online services on the basis that things like Facebook, etc., they are regarded as ceasing to be a child at 13. But at the moment, we don't yet currently have guidance which covers all aspects as to when an individual ceases to be a child. One thing that you should be aware of is that regardless of that fact, is that you shouldn't require parental consent for preventative and or counselling services. So a child of any age you can potentially provide counselling services to without parental consent, and this is something that is confirmed in the Data Protection Bill. The Data Protection Bill hasn't been finalised, so it is possible that it might change going forward, but certainly at the moment that will be the position in relation to counselling services. Looking at lawful purposes or how you legitimise your use of special categories of personal data, in addition to the lawful purposes we've been talking about, you also have to show that you've got an additional purpose to enable you to use the special categories of data. As we've talked about, get an extra layer of protection, so you have to make sure that you can definitely use it by looking at both lawful purpose and these additional lawful purposes. You'll see that consent is still in the mix, however the consent there is explicit, and so it has to be very, very clear that you have obtained the consent of the individuals concerned. One of the things that will be useful in an employment context, if we're unable to use consent even for special categories of personal data, is necessity to comply with obligations under employment law or to exercise rights relating to employment, social security and social protection. That will be very important. It will be useful if we get some guidance from the ICO to confirm what happens in the employment context with special categories of personal data, because certainly a lot of employers will use explicit consent to be able to process health and other types of personal data which fall within the definition of special categories. I suspect that the ICO will maintain the position, but there may be some relaxation for particular purposes, or it may be made clear as to what exactly falls within the second bullet point that we're talking about. You'll also see that it references vital interest, as I've said. That covers very serious situations, life and death situations. There's also an ability to make to sort of use the personal data if it's being made public, necessary for establishing or defending legal claims, or public interest in terms of the substantial public interest. So it's worth thinking about these things in terms of legitimising your use of special categories of data. In a nutshell, if you can't establish lawful purpose, then you shouldn't be using the personal data, because you are in breach of the legislation to do that. One of the key things under GDPR is that you are transparent and clear with people about how you are using their personal data. What that means from a practical point of view is that you need to revisit your privacy policies and any statements in terms of fair processing notices or transparency notices that you've issued to people to make it clear how you are using their personal data. Articles 13 and 14 of GDPR set out a list of things that you need to make sure are covered in your privacy policies. That list is quite a long list, and I'd be surprised if everything is currently covered in your privacy policy. So, for example, one of the things that most people don't currently cover is how long you keep the data for. But data retention periods is something that you are meant to be clear about in your privacy policies going forwards. What I would therefore suggest that you do is that you collect together any current statements that you have and think about whether or not they are GDPR compliant. GDPR compliant doesn't just mean that you have to hit the topics which are in Articles 13 and 14. I was recently speaking at an event at which someone from the ICO was also speaking, and they were emphasising the need for the information to be provided in a concise way. Their view is that if you have a lot of information and it's hard to navigate and people can't find what they want to know about how you're using their personal data easily, then essentially you've obscured how you're using the personal data and it's not transparent. So concise is important. What that means is that you need to think about layered policies. So, for example, if you're providing information online, you could click through for further information, or you could expand and contract boxes and things which provide the information that you're talking about. But it is something that needs some quite careful thought. The other thing is that it needs to be easily accessible and understandable to the people that it's addressed to. Now, this potentially provides a particular problem to schools, because if you are having to provide transparent information and a privacy policy to students, then it needs to be understandable by them. And if a decision is taken that you have to provide that to students who are 13 potentially and above, then obviously how you might communicate that in that situation is different to how you might communicate with somebody who is a supplier and is a business on a business-to-business basis. So that needs something quite careful thought. Essentially, it's horses for courses.
So in terms of the different privacy policies that schools should be looking at, what are the different audiences that would be key for those schools?
I think what you need to think about is that certainly there will need to be some transparency with pupils, because even if the age is set at 16, most schools will be engaging with students who are over the age of 16, so there does need to be some transparency with students about how their personal data is used. Also, you've got parents in the mix for prior to the age when you have to engage directly with students. You will have employee data, and also you will have potentially supplier data. So, for example, you may have suppliers to the school who may be sole traders or partnerships, or you may be storing personal data relating to individuals within companies. So you need to think of all the people that you collect and use personal data for, and think about, will you be clear in your privacy policies with them as to how you're using personal data. I think you also need to think about where you're going to put it, in terms of, are you going to put it on the website, how are you going to communicate it. Certainly I would recommend active communication. I would also recommend that, for example, you don't bury the privacy information in any student contract or contract with parents or anything of that nature. It should be a standalone document that's drawn to the attention of the individuals. The next topic we're going to have a look at is data retention. You need to have a look at the data that you are holding. I would suggest as part of your data audit, you should think about getting rid of data that isn't needed any longer. What's the point of becoming compliant with data that has no use anymore? In any event, under GDPR, you are required to think about how long you keep personal data for. You should not keep personal data for any longer than is necessary. So what that means is that you need to think about individual data streams and set retention periods on a data stream by data stream basis. One size does not fit all. I have a number of people that have suggested to me that their retention period will be 6 years for everything. That doesn't work. What you need to think about is, how long should I keep this particular piece of personal data for, and what's a reasonable period. I would also suggest that you document that. As I mentioned earlier, not only do you have to do the right thing, but you have to document the fact that you are complying with GDPR. So I would suggest you have a data protection policy in which you document for the data streams how long you are keeping it for, and document any reasoning behind that. So, for example, it may well be that you need to keep certain information for a long period of time. One of the things that we're coming across when we're talking to people is that quite often individuals don't think about pension until they get towards the end of their career, and then will go back to previous employers and ask for details of the pension. So it's potentially legitimate to keep the personal data for a period of time so that you can answer these pension queries. And so that's something that does need to be thought about. The other thing you need to think about as part of this is data minimisation, in terms of, should you be keeping the amount of information that you are keeping? Have you got too much information to achieve the purpose? What you should be thinking about is getting rid of excessive information that's kept just in case, information that's been kept for too long. Something that you need to think about very, very carefully. One of the other things that factor into this decision are claims, in terms of if there is a potential for a claim being brought in relation to any particular piece of information. Then again, the limitation period, the period in which somebody could bring a claim and sue you, then that feeds into what your retention period could be. You'll see that I've mentioned on the slide that you need to think about destruction of data. Data destruction is a very important part of this process. Particularly, any data needs to be destroyed, any personal data needs to be destroyed in a secure manner. So any personal data should at the very least be shredded by a shredder on site, which shouldn't be a strip shredder, it should be one that sort of chops it into very small pieces. Alternatively, you can engage a third party to provide shredding services to you. If you engage a third party, and it's something we'll be talking about a little later, you need to think about what they're going to be doing and making sure that they are complying with obligations under GDPR and with data protection legislation. Certainly there was a situation where a business engaged a third party to digitise their records and then to destroy the paper records. Unfortunately, the person that was given the job of getting rid of the paper records took it to a supermarket recycling bank and pushed it in the paper recycling bin. The paper recycling bin was full, and so they left the paper records next to the bin and left them hanging out of the bin. The data concerned was quite sensitive, and people around, when they saw what had been left near the recycling bin, were notified the ICO and action was taken. So it is very important that you think about secure destruction as part of your data retention policy.
Does the ICO have any guidance that schools can have a look at about retention periods?
They do. What they have helpfully done is they've published their own retention periods in relation to various types of data, which can provide a sort of starter for 10 for you in terms of, well, if the ICO is keeping pensions data for this length of time, then maybe I could think about whether or not that's suitable for what I'm doing in school. What you can't do is just sort of go for what the ICO has adopted without any thought. You need to think about whether or not it's applicable for your school, but certainly it is quite helpful. What I would do is I would search for that on the internet and have a look at what they're suggesting, see whether or not that might work for you. We were just talking about using third parties to use and access and process your personal data. We're now going to have a look at contractual requirements with them. If you are going to use a third party to carry out a service for you, and they might access personal data as part of that service, then they will be regarded as a data processor. A data processor is a different concept to the idea of processing personal data. It's unfortunate that very similar terms are used for the two, but a data processor is someone that essentially accesses or uses personal data as part of carrying out a service for you, rather than the broader idea of collecting and using personal data. And the reason I mention that is because quite often people get confused in terms of whether or not they are a processor just because they're using personal data. So I think it's something that's probably worth thinking about. But if you engage a third party to carry out a service for you and they can access personal data, so for example, if they're doing IT support or if they're doing analytics in relation to student data, for example, then you need to make sure that you have a contract in place with them, so you need a written contract, and you also need to make sure that they've got GDPR compliant clauses in. If you've got a data processor, GDPR requires that certain topics are covered contractually with your suppliers. Now, the Data Protection Act used to, well it still does, have certain provisions in there that you are required to include with your data processors, but they were much more focused on data security. GDPR has a broader range of mandatory obligations that need to be included that look at GDPR compliance in a much broader sense. So what you need to do is to, one, find any arrangements with any processors, make sure that you have contracts in place. If you have existing contracts in place, then what you need to do is have a look at them to make sure that they're GDPR compliant. If they are not GDPR compliant and don't include the mandatory topics I've just talked about, then what you need to do is make sure that they are varied, and certainly it's in the data processor's interest to make sure that they are GDPR compliant in the same way that you are, because processors have direct obligations under GDPR in the same way that you will as a data controller, controlling the collection and use of the data. The other thing that obviously you need to think about is if you are entering into new contracts, you need to make sure that they've got GDPR compliant clauses in. What we were previously saying to people when we were further out from May is that you could consider two-tier clauses, so that there was a clause which was Data Protection Act compliance until 25th May, and then from 25th May onwards you had a GDPR compliant clause. That's probably becoming less necessary these days as we get closer to may, but if you've got a processor who's very resistant, if you're engaging them on a new contract, to going for full-blown GDPR compliance from now, then that is an option. The other thing that you need to think about is due diligence. You need to carry out data protection due diligence in relation to your processors. You should make sure that you are engaging somebody who's competent, that you're convinced and confident is competent to access and use your personal data in a compliant manner. What this means is that for existing suppliers, if you haven't carried out data protection due diligence already, then you should be asking them about it now. You should potentially be sending out a GDPR readiness questionnaire. If you send out a questionnaire or ask the question about GDPR readiness and they say GDP what, then clearly you have a problem and you should be thinking about whether or not they are the right processor. It should also be part of your procurement process. You should think about data protection due diligence when you're engaging a new supplier, if they're going to get access to your personal data or to a subset of your personal data when they're carrying out their service.
And we've mentioned analytics on pupils. Are there any other key areas that schools should be looking at where they might have data processes in place?
Yeah, there's all sorts of things that a school might have in place. So, for example, IT support, quite often that's supplied by an outside provider. Hosting arrangements, if you've got any online portals and things like that, they're the sorts of things in terms of virtual learning environments and stuff. So it potentially can be quite pervasive in terms of when you're using a third party and they can get access to sort of third-party data. So I think it's something that does need some quite careful thought. Not just in the context of students either. So for example, if you use a third-party payroll provider in the context of your staff, again, they will be a data processor and you need to think about this in that context. Moving on to training and data protection officers, you need to train your staff. You need to think about what staff have access to personal data and make sure they are trained accordingly. It is horses for courses. If someone gets access to more personal data or deal with it day in, day out, then they need a much better understanding of GDPR requirements than someone that only gets access occasionally. But everyone within the organisation in a school, on the basis that they are likely to access some form of personal data during their time there, should have some sort of data protection and GDPR training. A lot of people consider training as not being fundamental for GDPR compliance. I would strongly advise that you consider training very carefully, because having good quality regular training can make the difference between being fined and not being fined. So for example, if you were to have a data breach which is potentially caused by a member of staff inadvertently doing something that maybe they shouldn't have done in terms of revealing information over the phone or something like that, then whether or not they have been trained, the quality of the training, and also when it was refreshed, will be relevant to the ICO in determining what action to take against you. So training is very important. You should also think about whether or not to appoint a data protection officer. A data protection officer is not required in all situations, but it is required in certain situations, particularly where there's a lot of monitoring of sensitive or special categories of personal data, or systematic monitoring, or where you've got processing carried out by a public authority. In the context of schools, I think it's generally being accepted that it's wise to have a data protection officer. A data protection officer, if you, for example, you're a multi-academy trust, can be somebody that's appointed across a number of schools. It doesn't have to be a full-time job. It can be somebody that combines it with their existing role. And also I think it's probably worth bearing in mind that if you're going to appoint a data protection officer, whoever takes up that role is then not a sacrificial lamb to the ICO. Essentially they're there to assist and advise the school in relation to data protection obligations, to monitor compliance, to deal with either carrying out the staff training or engaging somebody to do it, and to also be the central point of focus in terms of if there's any complaints or any liaison with the ICO. But they are very much not a sacrificial lamb. They don't have personal liability. But schools should certainly think very carefully about the what to do in the context of a data protection officer.
And if a school makes a decision that it doesn't think it needs a DPO, is there anything else that it could do to help with GDPR compliance?
Yeah, I think if you do take the decision that you don't need a DPO, then what you should do is have somebody that's the focus of compliance. What you need to make sure is that you've got somebody that at least can collect together queries and will know where to feed them to or can seek external advice. What you don't want, and we'll see it in the context when we talk about individuals' rights later, so for example, if a subject access request is received by the school, what you don't want is that it goes from pillar to post within the school because nobody really knows what needs to happen with it. There needs to be somebody that everyone understands, certainly is the focus of data protection activity, even if you choose not to appoint a DPO. We've just been talking about how best to deal with and someone being the focus of subject access requests. Essentially, a subject access request is where someone wants to know what personal data you are holding on them and how you are using it. They are something that is permissible under the Data Protection Act. Under the Data Protection Act, then you can charge a fee in relation to individuals. So, for example, a staff member who may want to know what personal data you hold on them. So you can charge a £10 fee and you have 40 days in which to respond. Under GDPR, you won't be able to charge a fee and you will have a calendar month in which to respond to individuals. It is possible in exceptional circumstances to extend that month, but as I say, I was recently at an event at which someone from the ICO was speaking, and they were very clear that it's exceptional circumstances, so you shouldn't rely on that extension as a matter of course. What this means is that you do need somebody who is the focus of what to do in the event of a subject access request being received, because a calendar month is not very long to review the request, consider what information you are holding, and get back to the individual concerned. One thing that does need to be borne in mind is that any personal data is the child's personal data, so the question is who should make a subject access request in relation to a child. If a child is very young, obviously it will be those with parental rights who will make the subject access request. So that does need to be borne in mind. But as a child gets older, and we've been talking about when a child ceases to be a child, then they will have the right to make a subject access request on their own account. In addition to subject access, there are additional rights under GDPR for individuals. One of those additional rights is the right to be forgotten. It's actually technically a right of erasure, but it is called the right to be forgotten, and the press have got hold of this right, and there is a lot of misinformation circulating in relation to it. There seems to be a misconception that it is an ability to ask anybody that has any of your personal data to erase that personal data. That's not the case at all. It only applies in limited circumstances. So, for example, where the use of the personal data is based upon consent, and that consent is withdrawn. Where the use of the personal data is no longer necessary, where essentially processing the data is unlawful, and also there is an ability to object and exercise your right to be forgotten in terms of if you're processing on the basis of legitimate interest, you can get people to essentially explain what the legitimate interests are, and if they're unable to do that, and be able to articulate that they've carried out the balancing act we were talking about, then potentially that data has to be erased. I think the key to this is the scope of the right is much narrower than the press will lead people to believe. So, for example, we understand that people are already considering that the right to be forgotten enables people to write to people to say you have to forget the fact that, you know, I've not previously paid my gas bill for the last 3 years or something like that, and that you can't therefore take action against them, or you can't refuse to give them, say, a new mobile phone if they've not previously paid their previous mobile phone contract. And so there is a misconception about it because that's certainly not intended to be what it's used for. I think the challenge that schools will face in relation to the right to be forgotten will be the people that will think that they have a right to be forgotten because the press or television have told them they've got a right, but in actual fact they don't have the right to exercise it. and so you'll be giving them bad news. So what I think you do need to do is have somebody who is the focus of this, who understands the scope of it, so that they can either liaise with the individuals or seek external advice in terms of whether or not the right applies. Equally, what you don't want is someone who doesn't understand the right and who will erase data from your systems when there's no need to do that, because then you'll be losing valuable data sets. So, for example, if you've got another ground enabling you to use the personal data other than consent, the fact that consent is withdrawn, if you have another right, that will potentially allow you to continue to use it. And you need somebody that understands these sort of fine details in relation to the right to be forgotten, or at least recognises the fact that the right to be forgotten gives rise to an issue in order to take advice. There are other rights given to individuals. So, for example, there is a right of data portability. That's again limited in scope, and there's a right of rectification in terms of being able to have your data rectified if it's incorrect. I think whilst we don't have time today to go through those, because this is very much a quick canter through GDPR, it is worth the school understanding what those additional rights are. One of the other things that needs to be thought about by a school very carefully is data breach. Currently, if you have a data breach, you don't have to notify it to the regulator. Where it's a serious data breach, then you are encouraged to notify it, but it is not compulsory to notify. Under GDPR, then in certain circumstances, data breach will have to be notified to both the regulator and to the individuals concerned. Data breaches will need to be notified to the regulator unless you can demonstrate that the data breach is unlikely to result in a risk to the rights and freedoms of the individuals. It also needs to be notified to the individuals concerned where there is a high risk to their rights and freedoms. So as you'll see, it's two different tests. You more likely, in view of the different tests, have to notify to the regulator. Any notification to the regulator under GDPR needs to be done within 72 hours of becoming aware of the data breach. And some guidance has been issued by the Pan-European Advice Body, the Article 29 Working Party, about when you are aware. And certainly you are allowed a short investigation into what's happened. Certainly what you can't do is have a prolonged investigation and just pretend that you are not aware for a long period of time before you go to the ICO and explain what's happened. In view of the very short timescale that you have, you should definitely be prepared for data breach. You should understand what you will do, who will be involved in assessing the data breach, and deciding whether or not it's something that is notifiable, what action to take in order to rectify it. We recently did a survey in connection with YouGov, and one of the things that came out of that is only 32% of educational establishments are confident they could notify within the relevant timescale.
And in terms of a data breach, are there any situations where a school wouldn't necessarily need to tell the individuals who have been affected?
Yes, absolutely, Claire. There are essentially three exemptions where you don't have to tell the individuals that there has been a data breach affecting their personal data. One is where there's technological or organisational protection measures. So, for example, if a USB stick or a laptop's lost and it's fully encrypted, then you would argue that there were technological measures in place which meant the data couldn't be accessed. Similarly, if you've actually taken pragmatic action, which means that the risk is eliminated. So, for example, if you were to leave a laptop on a train and a colleague was travelling with you and they picked up the laptop and gave it you the following day or got off the train with it, then again, since there's no possibility that anyone could intervene and have a look at what the data was, then that would be regarded as having eliminated the risk. There's a third one which on the surface sort of seems attractive but should be looked at with caution, and that's where notifying the individuals would involve disproportionate effort. As I say, it sort of seems attractive, but the thing you need to bear in mind with it is that essentially if you don't notify the individuals on an individual basis, then you will have to make a public statement. So you'll have to take an ad out in, say, example, the national press, or issue some sort of press release that gets very wide coverage. So from a PR point of view, I would definitely argue to avoid that exemption and engage with the individuals concerned rather than telling the world that you've suffered a data breach. So what's going to happen if you don't comply with GDPR? Currently, if you are in breach of the Data Protection Act, then the maximum fine that the ICO can levy against you is $500,000, which seems like a large sum of money. But when you consider the GDPR, the fines are much, much bigger. You'll see from the slide that there is a two-tier system. Certain breaches, then the maximum fine will be up to 10 million or 2% of global annual turnover, and for more serious breaches, then it will be up to 20 million euros or 4% of worldwide annual turnover. This is obviously particularly painful for group companies in terms of looking at the group as a whole and also looking at worldwide activities. So these fees are potentially very, very serious. One thing I would say, however, and I'm taking some comfort from it, is that when I was recently at an event with a representative of the ICO, they were at pains to point out to the audience that they will remain a fair and proportionate regulator going forward. So fingers crossed, a pragmatic and fair approach will still be taken by the ICO in relation to fining going forward. One of the other things that you need to bear in mind in relation to what might happen for a breach of GDPR is that there is also the possibility of individuals suing you in the civil courts and making claims in that way. And certainly we understand that there are group actions which are currently in the offing, and so it is something that you do need to be quite careful about, on the basis that in addition to being fined, you could face having to pay out damages to any individuals affected. So in summary, what do you need to do to become GDPR compliant? These are the headline issues. There is a lot of complication to GDPR, but this is what we would say as being the things that you needed to think about in order to become GDPR compliant. You need to carry out a data audit. You need to understand what data you have and how you are using it. If you're a business of over 250 employees, you need to document that in a mandatory record. You need to have a look at the basis that you're using the data for in terms of, is it legal? If you are using consent, then you need to review your consent. GDPR consent is different to data protection consent, and that's one of the things that you need to think about quite carefully. Pre-ticked boxes are not consent from a GDPR point of view. There has to be active consent given. You need to look at how transparent you are with people about how you are using their personal data, so you need to revisit your privacy policies. You need to look at how long you're keeping data for. You need to set a retention policy. You also need to think about whether or not you're keeping too much data. Hand in hand with the data retention policy is that you need to minimise the amount of data that you keep, on the basis there is a requirement that you minimise the amount of data. You need to review your contracts. You need to make sure you have contracts in relation to any arrangements with processors. You need to make sure they've got the mandatory clauses in. You need to carry out staff training. As I said, it's horses for courses. Anyone that handles a lot of personal data needs to have much more training than someone who just occasionally gets access to it. You need to think about whether or not to appoint a data protection officer. You need to set a number of policies and procedures in relation to how to deal with the enhanced rights of individuals. What will you do to deal with a subject access request? What will you do in terms of the right to be forgotten? There are additional rights of individuals as well, which you need to think about, which is the ability to rectify data and the ability to request data is given to them in a format to enable them to make it portable in certain circumstances. So that's something you need to understand and prepare for. And finally, you need to think very carefully about data breach. You need to prepare for data breach, because if you're going to have to notify within 72 hours to the regulator, you need to know what you're doing. So that's GDPR in a nutshell. It's very much a quick canter through, but hopefully it's been useful in terms of pointing you on key topics in the right direction.